Wisconsin gives landlords broad freedom to set and raise rent, but the state has specific notice requirements that you must follow, and they're more detailed than what you'd find in many other landlord-friendly states. The governing law is found in Wisconsin Statutes, Chapter 704, which covers landlord and tenant relations, along with the state's administrative code provisions under ATCP 134. Let's start with the big picture. Wisconsin does not have rent control. There is no state statute that caps how much a landlord can raise rent or how often increases can occur. In fact, Wisconsin has gone further than simply not enacting rent control. The state has a preemption statute that specifically prohibits cities, villages, towns, and counties from enacting their own rent control ordinances. Under Section 66.1015, no municipality in Wisconsin can establish ordinances or resolutions that limit the amount of rent a landlord can charge. This means that unlike states where individual cities have enacted local rent control, like New York, California, or Oregon, Wisconsin landlords face a uniform statewide framework with no local rent caps anywhere in the state. This preemption gives Wisconsin landlords certainty. You don't need to check whether your specific city has enacted rent control because none of them can. The rules are the same whether your property is in Milwaukee, Madison, Green Bay, or a small rural community. Now let's talk about the notice requirements, because this is where Wisconsin gets specific. For month-to-month tenancies, the landlord must provide at least 28 days written notice before a rent increase takes effect. Under Section 704.19, the notice must be given at least 28 days before the next rent payment date. So if rent is due on the 1st of the month and you want the increase to take effect on May 1st, you need to deliver the notice by April 3rd at the latest, 28 days before May 1st. The 28-day notice period is slightly shorter than the 30-day standard used by many states, but the difference matters when you're calculating deadlines. Mark your calendar carefully and deliver the notice with enough lead time to ensure it's received by the deadline. For fixed-term leases, the rent is locked in for the duration of the lease term, unless the lease itself includes a provision allowing midterm increases. This is standard across most states, without a contractual provision permitting increases during the term. The landlord must wait until the lease expires and negotiate the new rent as part of a renewal or new lease. When a fixed-term lease is coming up for renewal, the landlord should communicate the new rent amount well in advance of the renewal date. While the statute doesn't prescribe a specific notice period for rent increases at renewal, because you're essentially offering a new lease at a new rate, providing the tenant with as much advance notice as possible is good practice. If the tenant doesn't agree to the new rate, the lease expires at the end of its term and the tenancy either ends or converts to a month-to-month arrangement. For week-to-week tenancies, Wisconsin allows the landlord to provide notice consistent with the rental period, but the ATCP 134 administrative rules require that the notice be reasonable and clearly communicated. Now, let's cover the important restrictions that apply even without rent control. Rent increases cannot be retaliatory. Wisconsin has a specific anti-retaliation provision under ATCP 134.009 that prohibits landlords from raising rent as a form of retaliation against a tenant who has exercised their legal rights. If a tenant reports a building code violation to a government agency, files a complaint about habitability, contacts a tenants' rights organization, or exercises any other right under Wisconsin law, the landlord cannot respond by raising the rent. Wisconsin's anti-retaliation protection is enforced through the Department of Agriculture, Trade, and Consumer Protection, the agency that administers ATCP 134. If a tenant files a complaint alleging retaliatory rent increase, the department can investigate and take enforcement action. A landlord found to have engaged in retaliatory conduct can face penalties, and the tenant may be able to recover damages. The timing of a rent increase relative to a tenant's protected activity is critical evidence in a retaliation claim. If a tenant reports a code violation in January and the landlord announces a significant rent increase in February, the proximity in time creates a strong inference of retaliation. The landlord would need to demonstrate that the increase was planned for legitimate business reasons, such as market rate adjustments or increased operating costs, and was not motivated by the tenant's complaint. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and Wisconsin's own open housing law, found in Section 10650, landlords cannot raise rent based on a tenant's race, color, national origin, religion, sex, disability, familial status, sexual orientation, marital status, lawful source of income, age, or ancestry. Wisconsin's fair housing protections are broader than the federal law. The inclusion of sexual orientation, marital status, lawful source of income, age, and ancestry gives Wisconsin tenants additional protections that aren't available under federal law alone. This means that if a landlord raises rent for a tenant who receives Section 8 housing assistance or another form of government subsidy, and the increase appears designed to push the tenant out because of the subsidy, it could violate Wisconsin's lawful source of income protection. Landlords should apply rent increases uniformly across comparable units and document the business justification for each increase. Wisconsin also has important rules about how rent increases interact with the security deposit. Under ATCP 134.006, the security deposit for a residential tenancy is subject to certain limitations. If a rent increase causes the landlord to want a larger security deposit, the landlord must follow the proper procedures for requesting an additional deposit amount. The tenant is entitled to notice and the opportunity to pay the additional deposit in a reasonable manner. From a practical standpoint, Wisconsin's rental market varies across the state. Milwaukee and Madison are the two largest markets, and they have different dynamics. Madison, driven by the University of Wisconsin and the state government, has a tight rental market with strong demand, particularly near campus. Rent increases in Madison are common and often significant, especially for properties near the university. Milwaukee has a more diverse market with a wider range of price points, and rent increases tend to be more moderate in most neighborhoods. Smaller Wisconsin cities and rural areas have different dynamics. In communities where the rental market is less competitive, large rent increases can lead to vacancies because tenants have more options. Understanding your local market and pricing your units competitively is important for minimizing turnover while maximizing revenue. One best practice for Wisconsin landlords: provide written notice of any rent increase well in advance, even if you're exceeding the minimum 28-day requirement. For significant increases, anything above 5 to 10%, providing 60 or 90 days notice gives tenants time to adjust and reduces the likelihood of turnover. Good tenants are valuable, and a moderate, well-communicated increase is more likely to retain a good tenant than a sudden, large jump. Another best practice: include a rent increase provision in your fixed-term leases. A clause that specifies the rent for the initial term and outlines the process for increases at renewal gives both parties clarity about what to expect. Some landlords include a clause stating that if the lease renews, the rent may increase by a specified percentage or by an amount tied to operating cost changes. This sets expectations from the beginning and reduces the chance of disputes at renewal time. Wisconsin also has specific rules about rent collection and receipts under ATCP 134. While these don't directly regulate the amount of rent, they affect how rent is collected and documented. Landlords who want to raise rent should make sure their collection practices comply with these rules to avoid inadvertently creating problems. For the complete guide to Wisconsin rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.